Welcome, everyone. Today, we're going to walk through the essentials of trademark protection, what trademarks are, why they matter, and how to file correctly with the USPTO. Our goal is to break this down into clear, practical steps that anyone starting or growing a business can understand. Protecting your brand isn't just a legal formality, it's part of building trust, credibility, and long-term value. Before we dive in, just a quick disclaimer. This presentation is for educational purposes only. It's not legal advice, and if you need guidance for your specific situation, make sure to consult with a qualified attorney licensed in your jurisdiction. Before we jump into the mechanics of trademark searching and filing, let me introduce you to Pepe. Pepe lives in Central Valley here in California and runs a small business consulting firm called Ayuda Paisana. He's been operating for about a year since finishing business school. Pepe's business is doing very well and has expressed interest in how he can best protect his brand, which brings us to today's topic, why trademark protection matters. Before Pepe ever sat down with an attorney, he had a lot of the same misconceptions that many small business owners have about trademarks. The first thing he said was, well, I registered an LLC, so that means I'm protected, right? Then he added, I even bought the domain name. Doesn't that count for something? After that, he said, well, my business is too small to matter. And finally, he said, I can just put a TM on it and call it a day. These are incredibly common misconceptions, but none of these actions, forming an LLC, buying a domain name, being small, or simply using TM actually grants trademark rights. That's why filing correctly with the USPTO is so important. Another big misconception is that having a trademark means you own a word or phrase outright. In reality, trademarks only protect how a word or phrase is used with specific goods or services, not all possible uses of that word. So Pepe schedules a meeting with an attorney to understand his options. And that takes us into trademark fundamentals. So what exactly is a trademark? A trademark can be a word, a phrase, a symbol, a design, or a combination of any of these. It's essentially the identity of your brand, the way customers recognize you in the marketplace. Think of examples like Tiffany's iconic blue color or the Nike swoosh sign. When people see these, they instantly know who the source is. That's the power of a trademark. It tells consumers this product or service comes from this specific company. Trademarks exist on a spectrum of distinctiveness, from strongest to weakest. The more distinctive your mark is, the easier it is to register and protect. On one end, we have fanciful or arbitrary marks, like Kodak or using Apple for computers. These are the strongest trademarks. Then we have suggestive marks, like Netflix, which hints at what the service does. Next are descriptive marks, which describe a feature or quality of the product. These are very hard to protect unless they acquire distinctiveness over time. And finally, we have generic terms, which can never be protected. This would be like trying to trademark the word computer for selling computers. Understanding where your brand name fits on this spectrum helps you know your chances of approval at the USPTO. When we think about trademarks, we usually think of names or logos, but trademark protection also covers something called trade dress. Trade dress refers to the overall look and feel of a product or its packaging. It's the visual appearance that makes consumers immediately recognize the source of a product, even if the brand isn't visible. One of the most famous examples is the Coca-Cola bottle. Even without the label, most people can identify it instantly just from its unique contour shape. That distinct, recognizable design is considered trade dress. It's important to note that trade dress can't be functional. In other words, the design or shape can't be something that's necessary for how the product works. It has to be a creative or distinctive element, not something driven by practical function.
So, Pepe has decided he would like to file for a trademark. The most important thing to do before actually filing for a trademark is to actually search the mark. So this is how the steps on how to do a trademark search. The first thing that Pepe will do is he's going to go to the trademark database, which looks like here. He would go to search on trademarks and then click search trademarks. You can also get there just by looking up the USPTO trademark search database. When you get to the screen, it'll look something like this. On this screen, there are many different options on the left side about how to do a trademark search. One of the options is general search. This will be your most common basic way of searching. You could even narrow it down further and do a word mark search where you search for certain words and specific marks. You could also do like a design code, for example. This is a way to go into the USPTO website, find the design code, and that correlates to a specific type of design and search that way. The most complex way of searching will be your field tag or field and search tag search. That's an example you would have to do if you really want to do an advanced way of searching. On the top, you can also see that you must be in expert mode when you do a trademark search. This will maximize all the options that come up when you start searching. So let's give an example. Pepe goes to the website, he types in Ayuda Paisana and clicks search. What comes up is 58 different results. On the left side of the screen, you'll see a status filter. On there, you'll see live applications and also dead applications. Live applications are marks that have either been registered or are pending. Then there are dead applications. You might ask yourself, why do I care about a dead application? Well, there's a few key reasons. One example is businesses just sometimes forget to keep up with their filings. That means that they're still using their name out in the world, but on the USPTO, it'll show up as dead. They still might have some protection, so it's important to always look there as well. Another option is sometimes trademark applications get rejected. And if you see one that's been rejected that kind of looks similar to your mark, you can start looking and figuring out why the USPTO rejected their mark to try and fix your personal application. So here Pepe has done his search for the general search. Another great way to search on the USPTO website is to do a goods and services search. A goods and services search is where you basically go onto USPTO website, figure out where your brand fits underneath either the goods or services. The reason the USPTO breaks this up is that sometimes certain names can be similar, but they exist across different goods or services, and that's okay. An example is Dove chocolates and Dove soaps. They're two very similar names, Dove and Dove, but they're very different products. Dove soap is more personal care, Dove chocolates, that's something you eat and enjoy. But these two names can coexist across the different goods and services within the world. So here, Pepe would have to select Class 35. Advertising and business. He's a general consulting firm. It fits right underneath Class 35. He goes back to the USPTO website. He goes to the left side of the screen. He sees class filter and he selects Class 35. The key thing to know is at the top, right underneath the word class filter, you'll see a coordinated button. You always want to make sure that that's toggled on. The reason is because, like we said before, certain goods can exist across certain marks can, let me start over. Okay, I'm gonna go into this next, sorry. So Pepe goes back to the website and he clicks on his class filter and selects Class 35. At the top right underneath class filter, you'll see coordinated. You'll wanna always ensure that mark is toggled on. That ensures that when you begin searching underneath Class 35, it'll also include other industries that are similar to yours. For example, it'll include classes 36, 37, 38, and so on. You can imagine a world where there is Ayuda Paisana, a business general consulting firm, and then there's also a financial firm that does consulting as well, also called Ayuda Paisana. That would fall underneath Class 36. So when you're doing a trademark search, it's always important to make sure you're searching across different industries as well. Another reason to do this, to have the coordinated toggle button on, is because there are sometimes when you think, I want to expand a business later. I'm thinking 3 or 5 years down the line, I want to start getting into maybe the IT sector. So let's say Pepe decides in 3 years, I'm going to start an IT consulting firm. But he wants to make sure that he could still use that name that he has for his general consulting business. So he also wants to ensure the button 42 is also on to begin searching there for that trademark. The most important thing to know is that even if you don't do a class coordinated filter search, the USPTO themselves will do it when they're reviewing your application. So it's always best to save time and money by doing it yourself to see if there's anything else, any other businesses that fall within the same goods or service industry as you. The next important thing to do is to conduct a translation search. The USPTO requires that if you search a mark in a foreign language, you must also do that same translation in the English language. What this means is that sometimes translations are kind of difficult or it's really subjective, and the burden's on you to try and prove that. So here, an example would be that let's say you search up the word or you have a foreign language and you need to try the English translation and you put the word brighten. You'd probably also want to include like shining, luminous, radiant, some of the other words that might come into a different translation. So Pepe decides it's time for me to try an English translation search. He types in the English translations, help for a countryman. Notice the difference here. This one pulled up 6,007 results compared to the original 58 results. This means that Pepe will now have to do an entire trademark search all over again using the English translations. Imagine a world where there is a consulting firm called Countryman Consults. That might cause some issues down the line for the USPTO. So you want to make sure you're always doing a conductive trademark search. The next important thing to do is just try a Google search. Sometimes companies or businesses or individuals use a name that they never filed with the trademark or with the USPTO website to get a trademark. This means that they still might have some protections within their geographical area, and those are some things to always consider when you're doing a Google search. Make sure to always parse through multiple pages of Google. You never know what's going to come up first on your search compared to the next person's. The one thing I really want to emphasize is that the USPTO has a free version of how to do a trademark search that's much more in depth than what I'm able to cover today. I really encourage you to check it out. You can just search it up on YouTube and you'll find it. So let's say, for the sake of argument, that Pepe does his search. He finds a user that's using the same or similar name to his, Ayuda Paisana. What happens now? There are 3 common options. Note that these are not the only options that happen, but they're often the 3 common ones that people will use. And your options will depend on your specific circumstances, and you're always encouraged to reach out to an attorney to talk more about this. So one option he could do is just ignore it and file it anyways. Maybe this name is not quite in the same service as him or the same industry as him, or maybe he thinks it's a little bit different and there might be a chance. There's some risks with doing that because anytime you file a trademark, it does cost money. So you'll have to weigh your own circumstances compared to the one you're finding when you're doing a trademark search. The next option is offer a coexistence agreement. A coexistence agreement is a formal agreement between you, the individual, and the other person who has the same or similar mark to your company or your trademark that you're hoping to file. This is a great way to kind of just create a contract that says, we won't sue each other for any trademark infringements. You can set specific geographical boundaries. So Pepe's Ayuda Paisana consulting firm, it's in California. Imagine he finds another one that's all the way in New York. It's across the country. He could offer a coexistence agreement that says, I'll stay in the West Coast, you stay in the East Coast. And everybody's happy that way. Another great way to do a coexistence agreement is to set specific language that will differentiate your 2 brands. It really will depend on your circumstances and how same or similar and how best a relationship you can make with the other individual. The last option is just change your name. Pepe's about a year into business. Maybe he doesn't have that much brand recognition yet. Maybe it's a lot cheaper to change it now than later. It really just depends on your circumstances, how far along you are in your business, and how much money you want to invest in this specific trademark. But for the sake of argument, let's say Pepe has now decided there's no one who has the same or similar mark as him. He's now going to file with the USPTO.
Now that Pepe has done his due diligence in checking out the trademark, he's ready to apply. So now we'll go to the uspto.gov, and on the top left-hand corner, you'll click on My USPTO. This would then prompt you to go into create a uspto.gov account. You need an account in order to fully register and monitor the progress of your application. When creating an account, you'll need your email address, your first name that's on the driver's license or passport you would provide to the USPTO, your last name, as well as your street address, the same as the one on your passport or driver's license you'll provide to the USPTO, and a working phone number so the USPTO trademark examiners can contact you with any questions. After you have your account, you'll go to the home page and you'll click on Apply Online under Trademarks. When you apply online, you have to agree to the terms and use of the Trademark Center. Make sure you click on I agree at the bottom of your screen. Your first step in applying is to understand that there is a cost and fee to apply for the trademark. When you are applying for the trademark, you'll have different options, and first option, trademark/service mark principal register, will cost you $350, and that is the one you want to choose. You will have to choose whether you are an individual owner or an entity. For our purposes, Pep is an independent consultant, so he'll choose individual owner. Now, Pepe did his research, so he has all his information, but there is an insufficient information fee where you can continue and apply for your trademark without all the information available. But Pepe will now click No Return to Page because he has all his information. When applying to your trademark, you'll have to enter your country of citizenship. If you're a U.S. citizen, you choose United States. If you're just a resident and a citizen in a different country, you'll choose that other country. Make sure to always include your name, address, email address, citizenship phone number, and a website to your company or trademark if there is one available. So you'll then go ahead and put in the owner's first name, and you'll then go ahead and tell the USPTO what type of trademark you want. There's the option of just protecting the word ayuda paisana, or if Pepe had a design he wanted to use, he can go ahead and protect the trademark licks. You can also protect uncommon trademarks, which would be a sound, a taste, a color, like Tiffany's. So in the box at the bottom of choosing the first option, which is just the word, you'll go ahead and you'll input your trademark word. Here, Pepe just put ayuda paisana. Now, the USPTO prompts you to read the proper way of choosing your filing basis. Here, we have a foreign language that is not English word to trademark. As Pepe did his due diligence and researched how his translation is protected with the USPTO, he goes ahead and clicks, yes, I have a trademark that contains other words that are not in English. He then clicks no to does any word or phrase appear in non-Latin characters, but if your trademark is in Arabic font or Cyrillic for Slavic languages, you'll go ahead and click yes. So the basis we're choosing for Pepe would be use in commerce. Pepe has a business, he's taking in clients, we're using it in commerce. Now, Pepe doesn't have a name, but if you had a name like, for example, Trump Inc., we need to make sure that that person who owns that name gave you permission to use that name. All right, so now we're telling the USPTO what goods and services we will provide with our trademark. With Ayuda Paisana, we have consulting. So here, under where it says search the trademark ID manual, that's where we would put professional business consulting. For additional information of our trademark, we'll go ahead and choose whether there are words or phrases in your trademark that you want to disclaim. That is, if you know somebody else is using it, but you have an agreement with them. Or there are words that are industry specific that can be considered generic. Finally, the USPTO makes you review and edit your application. You want to make sure that your contact information is correct, that all of the trademark detail, the name, all the permissions are granted, and that you identify the goods and services that you'll be providing. Once all of that is reviewed and accepted, you go ahead and you sign on the USPTO's website. And once you sign, your trademark is ready to be reviewed by a trademark examining attorney. That again takes about 6 to 8 months before it's reviewed. After you file, you want to make sure that you don't get an opposition within 30 days. And the enforcement, again, it is up to you to enforce. It is not up to the USPTO to enforce. And you have to have continuing use.
Once you file your trademark application, there are a few key stages you should expect regarding post-registration, enforcement, and closing. Here's what the trademark timeline actually looks like from start to finish. First, once you submit your application and the filing fee, the USPTO assigns you a serial number. That's basically your tracking number for the entire process. Next, around 4 to 6 months later, your application goes to an examining attorney. Their job is to review your application and decide whether federal law allows the mark to be registered. They look at the legal requirements and check whether your trademark is actually eligible for protection. If the examiner finds any issues, they'll send what's called an office action, which adds time to the process. You have to respond by the deadline and fix whatever they flagged. After that, your mark goes to the publication phase, which lasts 30 days. The USPTO publishes it in something called the Official Gazette, which is a weekly online publication. This is the moment when the public gets a chance to object or oppose your trademark. If nobody opposes it, the application moves to the final stage. And finally, if all goes well, you reach registration, which usually puts the whole process at around 12 to 18 months from start to finish. The USPTO will issue your registration certificate unless there was an opposition or legal issue that blocks it. So even at this final step, it's important to remember that there's never a guarantee of registration. But this is the typical path most applications follow. Lastly, after registration, there are a few key reminders we'd like to make you aware of. Once your trademark is officially registered, first, the USPTO does not enforce your trademark rights for you. Their job is to review and register trademarks, not to police the marketplace. That means you are responsible for monitoring how your brand is being used and making sure no one is infringing on your trademark. And if you do find a potential issue, the most common enforcement tool is a cease and desist letter. This is often the first step in stopping unauthorized use and protecting your brand. In the context of a trademark violation, a cease and desist is a letter sent to someone who is using your trademark without permission, telling them to 1, stop using the mark immediately, and 2, not use it again in the future. It puts them on notice that their use may cause consumer confusion or infringe your trademark rights, and that you are prepared to take further legal action if they don't comply.
Now let's focus on Roberto, because he's about to face the exact kind of trademark problem that many small businesses don't see coming. Roberto runs a small marketing agency in Central California called Ayuda Paisana. Back in business school, Roberto knew Pepe, who now runs a separate business consulting company also named Ayuda Paisana. They were not rivals, but they both liked the same name for similar types of services. A few months into running his agency, Roberto hears something strange from a client.
Roberto, I didn't know that your marketing agency was connected to a business consulting firm called Ayuda Paisana. Are you expanding?
No, that's not my business.
At first, Roberto thinks it's just a mix-up, but a few days later, he receives a USPTO trademark alert, something he set up to monitor names similar to his brand. A new trademark application has just been published in the USPTO Official Gazette for Ayuda Paisana. Realizing the name is identical to his own brand, Roberto starts to worry.
That's the exact same name I use, and it's for services close to mine. If that registers, clients could get totally confused.
Once a mark appears in the Official Gazette, the USPTO opens a 30-day window for anyone who may be harmed to oppose the application.
So my only chance is to stop this now?
Yes, you can file a trademark opposition, and that starts a formal legal process. We'll go through the steps next.
Roberto realizes he needs to act during this 30-day window if he wants to protect the identity of his business.
So, what is trademark opposition? Trademark opposition is a formal process where someone asks the USPTO to stop a trademark application before it becomes a registered trademark. It happens at the Trademark Trial and Appeal Board, the TTAB, which is like the USPTO's courtroom for trademark disputes. So, when can Roberto oppose this trademark? Only after the USPTO examining attorney approves the application and it's officially published in the USPTO's Official Gazette. This publication starts a 30-day deadline for anyone who might be harmed, like Roberto, to file an opposition.
So, now we're going to get into the notice of opposition. What does Roberto have to do to submit to oppose the trademark? First, he must file a notice of opposition within the 30-day publication period or after obtaining an extension of time. The notice of opposition is a short written explanation telling the USPTO why the mark should not register. For example, that it is confusingly similar to Roberto's name. Roberto must also pay the USPTO's filing fee of $600 per class of goods or services in the application. If the application lists multiple classes, the cost increases because the application fee applies per class. Fees are non-refundable even if eventually Roberto wins his case. Filing the notice of opposition officially starts his case.
Next, we'll discuss who can file a notice of opposition. Can Roberto even file? Yes, if he meets one requirement. He must show that he has legitimate interest in the outcome of the trademark application. In simple terms, Roberto must show that he uses the name Ayuda Paisana for his business, the new trademark application is the same or very similar, and the registration could harm his business. Roberto can demonstrate this by explaining he has been using the name in commerce before the applicant, and that a registered trademark for Ayuda Paisana for similar services could confuse customers, cause his business to lose clients, or affect his ability to use his own business name. If he can show that the registration would realistically impact him or his business, he has the right to oppose it.
Next, we're going to discuss the grounds for a notice of opposition. The most common reason that Roberto would oppose the application is likelihood of confusion, meaning the applied for mark is so similar to his own that customers might believe the services actually come from the same business. But that's not the only ground Roberto can rely on. A mark can be opposed if the mark is merely descriptive, which means that it describes a feature, quality, or purpose of the goods or services. These are weak as trademarks because consumers see them as descriptions, not as brand names. Or Roberto can oppose if the mark is generic. A generic term is the common name for a type of product or service. For example, saying soft drink for soda. Generic words can never function as trademarks, no matter who applies, because they don't identify any particular source. Or Roberto can rely on the fact that the mark falsely suggests a connection. If the applied for mark would lead people to mistakenly believe the applicant is connected to Roberto or his business, even if no relationship exists, Roberto can oppose the application.
So, what makes a good claim? What Roberto needs to do to have a strong opposition, he must base it on facts and real marketplace impact, not just personal feelings. For example, personal dislike is not a legal basis. He cannot oppose the mark just because he disagrees with Pepe or his business. The TTAB only considers legal grounds, not personal conflicts. Roberto must also show that he used the name first. Roberto strengthens his claim by proving that he used Ayuda Paisana in his commerce before the applicant Pepe. He must also show the registration would actually harm him by pointing to real-world facts, such as that customers might confuse the two businesses, he would lose clients, his ability to use his name or expand his business would be restricted. He has invested a lot in the brand, such as marketing materials or community events, and these investments would be undermined. Or he could be forced to rebrand or defend against infringement claims. Another thing is that he can raise bad faith concern only if supported by facts. If Roberto has evidence that the applicant filed without real intent to use the mark or filed to cause confusion or gain an unfair advantage. In short, a strong opposition depends on first use, concrete harm, and actual investment in the brand, not just based on personal disagreements.
Once Roberto decides to file an opposition, there are a few key steps he needs to take. First, he must actually file the notice of opposition. Roberto must submit a written statement explaining why the mark should not be registered. This is not long, it simply needs to be an outline of the main facts that show he has the right to oppose, which is called standing, and that there is a valid legal reason to deny the application, which are called the grounds for opposition. Next, he must state the core facts. Roberto does not have to prove his entire case at this stage, but he must provide enough factual information to show that he has used the name in commerce, the applied for mark is the same or confusingly similar as his own, and the registration would harm his business. He only needs a good faith belief that what he is claiming is true. Lastly, he must begin to prepare evidence. After filing, the opposition moves into a structured TTAB process where both sides exchange evidence, submit documents, provide testimony, and respond to each other's arguments. This is where Roberto will later present the proof to support his claims.
Now we're going to get into how to actually file a notice of opposition on the website. To start, Google search USPTO. Once on the site, Roberto will look to the left-hand side of the website that says New Submission.
Filing a new submission. After clicking on the new submission, Roberto will look under File a New Proceeding and click on the Notice of Opposition section.
Roberto will either need to sign in or create a new account if he has previously filed for a trademark. Once he is logged on to the USPTO website, he can begin to file his notice of opposition.
One important thing to note is, what if Roberto needs more time to file? Once the trademark is published in the Official Gazette, Roberto has 30 days to file an opposition. If he needs more time, he can request an extension. On this screen, Roberto will choose between a 30-day extension or a 90-day extension of time for good cause. The 30-day extension is free and automatically granted. The 90-day extension requires a $200 USPTO fee and will require you show good cause on a later page. If he's not ready, it's important to remember that while Roberto can request extra time, he cannot miss the deadline, because if he does, he permanently loses his right to oppose. On this slide, regardless of whether Roberto selects the 30-day or the 90-day extension, ESTTA will direct Roberto to this page, and he will fill in some information about him and his business. The TTAB will send all communications about the extension to the the email address included on this page. If Roberto selected a 90-day extension, ESTTA will then display a page asking him to show good cause. He can choose one or more of the listed reasons, such as needing additional time to investigate the claim, needing time to consult with counsel, being involved in settlement discussions, or just needing more time to seek representation. Roberto may also add a short explanation in the text box if needed. This page only appears when selecting a full 90-day extension.
So now for an overview. Once Roberto is ready to move forward, he has to file the Notice of Opposition electronically through the USPTO's TTAB system, otherwise known as the ESTTA. He has to pay the required filing fee at the time of submission. He has to include a clear written explanation of why the trademark should not register, such as his earlier use of the name and the risk of consumer confusion. Once he officially files his opposition, that starts the case at the TTAB.
After Roberto files the notice of opposition, the TTAB issues a schedule called a trial calendar, which lays out all of the deadlines. Pepe has 30 days to file an answer responding to Roberto's allegations. If Pepe files an answer, the case moves into a limited discovery period where both sides exchange information about how they use their marks in commerce, customer impressions, dates of first use, and business activities connected to the marks. If Pepe does not answer, the TTAB issues a notice of default, giving Pepe another 30 days to explain why he failed to respond. If he still does not respond, Roberto wins by default, and the application will be refused.
Remember, there are limits of the USPTO opposition proceeding. Even though an opposition is a powerful tool, it has limits. The USPTO can refuse or approve registrations, but it can't stop someone from using a mark in the real world. This means that Roberto may still have to enforce his right outside of the USPTO. The strongest way to protect your trademark is to register it as soon as you start using it, because it's harder to enforce rights in an unregistered mark. And only a federal court can issue orders stopping a trademark infringer from using a name. So, while a notice of opposition can block a registration, only courts can stop actual marketplace infringement.